That Karthik was not found guilty of rape, but guilty of other two offences with a sentence to 2 years imprisonment and rupees 25,000 rupees fine. Abhinaya approached the High Court of Manavai regarding this, where it got dismissed, stating that the laws of land did not recognize marital rape. Aggrieved by this, with the help of an NGO called B2, she filed a writ petition before this Honorable Supreme Court of Imada, number 1234 of 2021, seeking justice and to make marital rape an offence. This matter in state of Province got media attention, and a regional party called Democratic Movement of Province amounted to repeal the marital rape exception in section 375 of IPC in their election manifesto. And they got the majority in the subsequent election and they formed the government. The government passed a cabinet resolution to introduce the bill to remove marital rape exception. A women an association for men affected by section 498 capital A of IPC filed a writ petition in Manavai High Court. The High Court stayed the decision of such removal of government. The government appealed to the division bench of the High Court of Manavai, where the decision was divided, and the judges granted specially to appeal before the Honorable Supreme Court to implement the promise of election manifesto. The petitioner number 3, Priya was in a live-in relationship for 5 years with Sunil. They, in 2020, due to global pandemic, Sunil lost his job and there was a downfall in their relationship. And to some issues, it related to creating quarrels between them, and eventually it ended in him hitting her and forced himself on her that leads to body an FIR under lodge an FIR. On the ground, there was no marriage of evidence between them. She filed a writ petition before the Honorable Supreme live-in relationship can be considered as marriage, and marital rape can be brought under the purview of live-in relationship. Second, whether the implementation of election manifesto by a government is constitutionally valid. And third, whether the criminalization of marital rape is constitutionally valid. Your Lordship, the Council will be dealing with the first issue for 20 minutes for 20 minutes, and the second, and will be speaking for 20 minutes. The whole council will be dealing with the second and third issue and will speak for 20 minutes, and respectfully reserving 5 minutes for rebuttal. Much obliged, Your Lordship. The council seeks permission to proceed with the arguments advanced, Your Lordship. Much obliged, Your Lordship. Your Lordship, the first issue is whether the live-in relationship can be considered as marriage, and can marital rape be brought under the purview of live-in relationship. On behalf of the petitioner Kriya would like to argue by saying that live-in relationship can be considered as marriage and marital rape can be brought under the purview of live-in relationship, which council would establish on 3 grounds. Firstly, with changing times and social dynamics, live-in relationship evolved as a new form of marriage in this emergent society. Secondly, a non-consensual sexual intercourse by a partner in live-in relationship can be considered as a marital rape. Firstly, as the society changes, society being dynamic in nature has to be the same. The Indian judiciary and legislative has observed and recognized this in various judgments and amendments. For your examples, in 2014, the Supreme Court affirmed the rights of transgenders in Nalsa versus Union of India case. In 2017, as a fundamental right. In case Putusami versus Union of India case, in general term, it is a domestic cohabitation between two unmarried individuals. Even to be and for your reference, the concept of live-in relationship in this emergent conservative society is not new. Because a tribal community in Arunachal Pradesh called Kuki tribe follows a type of marriage called probationary marriage, in which the bridegroom enters into the house of the girl, live with that girl for a certain period of time. During this period of time, they examine each other's potentiality, courage, and understanding. If they were satisfied from one another, they will arrange marriage ceremonies afterwards, or else the man may leave the house of the girl, paying some compensation to the girl's family. So, in this emergent society, it is not a new kind of marriage. Yes, your lordship.
Yeah. Priya wants particular on the partner will be because as well married, but in the Sumatra society, Sumatra initially even does not recognize the married who are completely able to witness. Then how Priya will the benefit from that provisions or this book granted to the.
May may I ask you for the one pardon?
uh, as per immigrant legislations, cannot be recognized, cannot be penalized in that states that share in the section, a household means when a person agreed life or any states are included in the relationship, either simply or along with the respondent, and include such household or and the respondent are owned or tenanted by either of them in respect of with each other, your lordship. According to this section, the living partnership is recognized as a partners are recognized as a member of a family, your lordship. When the relationship in the nature of relationship in the nature of marriage has been fulfilled according to this section, your lordship. Next, and most importantly, while we are considering live-in relationship is not live-in relationship is considered not as a marriage, it's violating the Article 21 of the Indian Constitution, Your Lordship, which it has been stated in the case has been stated in the case Safin John versus Ashokan K.M. in the logic. Actually, the fact of this case, Safin John versus Ashok K.M. is what means your logic.
Sexuality and sexual harassment and rape. She wants her to be penalized for having a relationship that because the living relationship can be considered as a marriage.
She will go for the section 3 why she will go avoid the benefit from marriage. Avoid the penalized in the husband as well for marriage. Why is this more considered? This is a marriage. The eligible of Priya is a marriage. Proceed.
Much obliged, your lordship. In today's modernized world, the live-in relationship finds its roots in Article 21 of Indian Constitution, which confers every person the fundamental right to life and personal liberty, which is in its widest amplitude. It also confers the right and freedom of choice to either marry or to live in, relate to either marry or to have a live-in relationship with an individual of one's own will, thus emerges as an inalienable fundamental right, which is mentioned in Kushbu versus Kanyamal case by the Justice B.S. Chauhan. The Supreme Court also held that the live-in relationship was not illegal in the eye of law, even though it is considered as immoral in the eye of conservative American society, which was mentioned in Nandakumar versus State of Kerala case in 2018. In Badri Prasad versus Director of Consolidation case, the Supreme Court legitimized a 50-year-old relationship of a couple. The bench stated that since the couple had lived together for a long time, 5 years, Your Lordship, 50 years.
Already stated in that the Velusamy versus D. Pachamal case, living relationship has satisfied your lordship in that case, D. Velusamy versus Pachamal case, actually the Pachamal is claiming maintenance under section 120. But but this bench has decided that the living relationship can be considered as a marriage when
It's a presumption of a marriage when couples were living together for a considerable amount of time. Can I proceed with the much of the lordship? In Indra Sharma versus BKV Sharma case, which serves as a basic framework of our rule book for the matter in living relationship, the bench shielded that the words living relationship in the nature of marriage that encompasses in the section 2F of Protection of Women from Domestic Violence Act 2005 encompasses within itself the term live-in relationship under the in the term live-in relationship. As your lordship, by these judgments, it is evident that the Indian judiciary has recognized the live-in relationship and the more or less they equated with the Latin maxim ad eque frequentis accident jura ad appantio, which means the law has to be adapted to those cases which often occur in the society. Nowadays, with the increase in the number of live-in relationships, the people opting for a better version of marriages, the law must adopt and accept to social change and have to value the individual's opinion and to consider live-in relationship as a marriage. Moving on to the second ground, the can marital rape can be under the purview of live-in relationship. The section 375 of Indian Penal Code defines rape as a sexual intercourse with a woman against her will, consent, by coercion, misrepresentation, or fraud, or at a time when she has been intoxicated or duped or is of unsound mental health, and in any case if she is under 15 years of age, which in which the marital rape is not precisely defined, even though it is mentioned under exception 2, which states that a husband who is engaging in a sexual activity after marriage with the partner against the will or consent as an intercourse is not said to be rape. It's not commit under a rape. Even though the emergent society, whether against the will or consent, the rape in the course of marriage can be considered as a marital rape.
what is the council obligation of marriage? What is the council obligation of the married? How to discharge the council obligation?
Discharge conjugal
obligation. If we are penalized, that penalized as well married.
Your Lordship, may I ask you for the rephrase of your question?
What is the meaning of conjugal obligation?
I'm sorry, Your Lordship, I'm not sure about that. In order to support my grounds, the forceful sexual intercourse by a partner in living relationship constitute a marital rape. With, I like to quote some of the judgments and the observation of the judges that they recognized the vulnerability of a female partner in living relationship as that of wife in a marriage. In Badshah versus Urmila Badshah Godse, the Supreme Court held that the section 125 of CRPC 1973, which enacted to achieve social justice,
Um, there lots of live-in relationship only for in one day night or 2 day night. It's not considered as a live-in relationship. But comparing with this period of time along with the Canadian live-in relationship, when the living partners are in living relationship for more than 12 months, it can be considered as a living relationship period. Your lordship. Much obliged, your lordship. Finally, the Malimat Committee in 2010 it was observed that Supreme Court reported to the Supreme Court that a man and woman living together without marrying cannot be considered as an offence, your lordship. There is no law prohibiting living relationship or premarital sex. Yes, your lordship. Yes, your lordship.
live under the same roof and cohabit for a considerable years, there will be a presumption of marriage under Section 114 of Evidence Act, and child born to them will be considered to be a legitimate and rightfully entitled to receive the shares in their ancestral property. By here, they recognize the legal right of the child born out of the relationship too. In a case called Svetlana Kaziana versus Union of India case, the apex court
Merely a physical assault, it is often destructive of the whole.
manner. When the respondent submitted that the reason behind the denial of
Your lordship, according to the Nishaba Bharat Boy, which is state of Gujarat, which it has stated that marital rape can be considered in living relationship. Your lordship, that's the council. I hope council argued.
now the factum of life, the court said that grant of extension of visa granted an extension of visa to the Uzbekistan woman, saying that marriage and living relationship should not be treated equally. Here, the court treated the marriage and living relationship to be same, and the visa extension has been given to a partner in living relationship, female partner, like that of a woman in a marriage, wife in a marriage. I would like to conclude this by saying that Immigrant judiciary has delineated that living relationship and marriage should not be treated differently, and hence the sexual offense by a partner in living relationship should be considered as an offense by a man in like a marital.
What is the criteria for Hindu marriage?
Your
What
question.
are the criteria for Hindu marriage?
Hindu marriage. For legal, there has to be a legal age, and while marrying one of the spouses should not be alive. Should not be alive, or there has to be divorce.
Highly much obliged, Rashid. The fact really says that it is the implementation of election manifesto. Cabinet resolution was passed in order to introduce the bill to remove the. Much obliged, Lordship. Yes, the state can file a petition because here the state is doing its duty, which is provided under the Constitution Part 3, that is the principles of state policy of the Constitution. It is under a process of its duty, and while its duty is getting disturbed, it has the right to go against the order or the judgment or the degree. Yes, Lordship. Yes, Lordship. No, Your Lordship. Judiciary is not controlled. Is not controlling the legislature. But if in case of any loopholes in the legislation, the judiciary has the right to have a check over the legislation when there is a lacuna or a loophole.
Issue number 2, whether the implementation of election manifestos by the government is constitutionally valid. In my point of view, on behalf of the petitioner, we have argued in front of your respected Supreme Court of Himatha's bench. Yes, it is humbly submitted before that. It's valid from constitutionally valid because there are given the three grounds to prove in behalf of the petitioner in front of the Honorable Supreme Court. The first one is Part 8 of Model Code of Conduct, Annexure 18, explains the very clear definition, election manifesto guidelines for the political parties. How
That's the legislation for regulating the election manifesto. As per in the
much obliged, Your Lordship, there is no enactments.
That the High Court deciding the case, it favored women where it stayed the implementation of the bill which was in the the cabinet resolution. Much obliged, Your Lordship. In the cabinet resolution. So, challenging that, the High Court have went to the Supreme Court. So, it is the appellate jurisdiction of the Supreme Court where the state government. Article 132 of the Constitution, which says of the appellate jurisdiction of the Supreme Court of, against the order or the final degree of High Court under any for certain cases, and which have the substantial question of law. And under Article 132 of the Constitution, the state of the office. Much obliged, Your Lordship. So it is humbly.
Political parties for making these manifestos. In generally, manifestos means to serve as a reference document or benchmark of the public at large. What the political party stands for and what it offers or promises to offer to the electorate, in particularly if it comes to power. In this fact, we stated in before the Supreme Court of Himatha, we have not violating any other constitutional provisions. And in this fact, section 212 clearly says court does not interfere in the legislature. 212 of Indian Constitution, sorry, American Constitution 1950, the clearly says
This is being obstruct or restrained by the High Court. Before moving, I would like to say what is election manifesto under the chapter 18 of Model Code of Conduct. Election manifesto is given a definition. It says that it serves a reference document on the benchmark for the public at large for what a political party stands for and what it offers or promises to offer to the electorate, and in particular when it comes to the force or comes in power. Here, the election manifesto is not a big deal because election manifesto can be many things. Under election manifesto, one can provide freebies or other valuable consideration. But here, the nature of election manifesto is something different, which is to achieve something which is good for the public and which fulfills the common purpose. And also to continue the duty which is given under DPSP of the Constitution. Here, in the case at hand, the party during the election, looking into the regret, shameful and distressful, pitiful situation of women.
it is not a legislature. Then why this court has not power to step down the legislation?
much obliged, Your Lordship. We don't interfere any other court rules or court
A
law.
kind of protective shield. It's like a canopy where husbands are getting hidden from being to be considered as a convict under rape. Yes, Your Lordship.
Legislature do not interfere.
Legislature no mind.
Yes,
Legislature does not enter
enter the legislature domain.
Okay. Okay. If you are enacting this legislation, it's no, it is why that is why you are putting up the constitution or not.
Not
You are not equally protected to men community. It is not against them. If legislation is passed,
this legislation of
legislation is passed, it is totally against the men community. How you are protecting the equally as per the constitution?
the marital rape is considered, please consider as a criminalization. But in this resolution, we passed the removal of the marital rape exception to protect the woman.
You are protecting the women. but your bias is different. I'm right?
Uh, DPSP clearly says that means
Any articles available for the purpose of protection of human or
yes, my lordship. I humbly requested and before the argued that section 15 subclass article 15 subclass 3 of the Immortal Constitution clearly says the positive discrimination against the woman or children be like the state or the government passes any other cabinet resolution. This is not a discrimination, this positive discrimination category.
how the state government enacted for criminal law legislation in favor of children. Okay? Whether the state government having power to enact legislation and under the criminal law.
Yes, yes. Much obvious, Your Lordship. Yes, it's available. It's Article 254, sorry, 245. The concurrent list, rule, Table 1 criminal law is also available. In recognized constitution is provided that state also given the permissions and avail the any other legislations making to given the powers to the state legislature. It satisfies much obliged, Your Lordship. In this behalf, the election guidelines clearly says the election manifesto shall not contain anything repugnancy to the ideals and principles enshrined in the Constitution. And also, directive principles of state policy is only enjoin the state to frame various welfare measures for the citizens. Equal support for men and women. Therefore, there can be no objection to the promise of such welfare measures in election manifesto. In the interest of transparency, level playing field, and credibility of promises, it is expected that manifestos and also reflect the rationale for promises and broadly indicate the ways and means to the financial requirement for it. The legal enforceability of election manifestos clearly says according to a manifesto is defined is a promise, an offer, and anyone making a contract is stopped from denying promise, mad and could not be made accountable to it under the section 10 of the Emergent Contract Act 1872. At the conclusion of the judgment of election manifestos, the promise made before the election and upon achieving power, the state have a moral duty to fulfill. Election Commission of India also agrees because it is the statutory body recognized the immortal constitution. So this also agrees in the principles with the point of view that the framing of manifestos is the right of the political parties. The law obviously that the promises in the election manifestos cannot be construed as of People's Act 1951. If the council's permission to move on the next issue, much obliged, Lordship. Whether the criminalization of marital rape is constitutionally valid.
Given in the case, it does not contain anything which is repugnant to the idea, rather than it is trying to eradicate a crime or something, an evil which is prevailing in the society. And the implementation of election manifesto is for the welfare of the people, especially. Much obliged, Lordship. Here, husband being the dominant sector of the society and women be much obliged, Lordship. No, actually, it is already given. The Lord considers women as a weaker section, and here public welfare refers to the common good, which includes men and women. But here, when a crime is committed, when an act which is affecting a personal dignity of another individual, in that case, it is necessary to provide a proper solution for the aggrieved party. Much obliged, Your Lordship. Section 9 of Hindu Marriage Act says about restoration of conjugal rights. It says that if a husband and wife are separated. Yes, my Lordship, indeed it's available. the husband has the right to ask for conjugal relationship. But here the consent matters. Consent is the main important thing because the whole as we are living in this modern society, everybody have individual liberty, individual freedom. They can express their own self. So in that case, if one is not in consent to do some act, they have that full right to plea for their favor. Yes, my lordship. Yes, your lordship. There is equitable remedy which is
Human constitution
given
will
to both men and
not recognized. It's violated the Article 14, 15.
for that purpose, recently the rape or the term sexual things are which is given only to the men, like against sorry, given for the women against the men. Recently, the rape term itself is changed into sexual assault, where that law is trying to make a gender neutral status, not gender specific. So men are also getting equality or
In
equity,
the
whatever it
council,
may be.
it's my opinion, the relationship, what is the meaning of marriage relationship or conjugal relationship? Conjugal
Much obliged,
relationship
Lordship.
only for love and affection, not only
Much
depending on
obliged,
sexual
Lordship, but
intercourse. More
I also would
many
like
of
to
the
say that
marriages in our
the
country,
law reports of the committees that have been
without qualifying
framed.
sexual intercourse, couples also live with her.
If we are going towards husband or protection, then how you can disagree?
Marital rape is the rape is clearly says with her consent, with her will and without her consent. It clearly says. But in this category, the married woman above the age of 15, if above the age of 15 years, is concluded as a with her consent also committed under the rape.
Okay. If we are
Is used by either parties. So in such case, we can come to the conclusion that there is a gender neutral. Much obliged, Your Lordship. The degree of comparison have to be looked upon. Like a government is for the welfare of the country, welfare of the state. So in such case, the degree of comparison, who is getting more affected, who is not getting more affected, should be considered. And considering that, the government have to bring laws and welfare schemes. Much obliged, Lordship. The Council seeks permission to move on to the third issue. Whether the criminalization of marital rape is constitutionally valid. It is humbly submitted before the Supreme Court that marital rape is an offence and is criminalizing is constitutionally valid. Before moving to the arguments, as I've said in my earlier arguments as well, that as a passerby in a court or a passerby in life, 5 minutes before marriage it was rape, and 5 minutes after marriage it is not rape. So considering that point, which makes a sense, that rape is a rape, and no matter who does it, where, how it is done, where it is done, who it does it. Rape is a rape, and no means no. Rape is an unlawful sexual desire with another person. So here, sexual intercourse is without the consent. And as we are talking mainly about marital rape and not about the broad sense of rape, marital rape is also an undeserved sexual course by a man with his own wife, which is achieved by unlawful force or threat. So marital rape comes into a place where there is no consent and there is a use of threat or force. The controversial part is section 375, exception 2, which says the sexual intercourse done by a man with his own wife not being under the age of 18 is not rape. So this part of section 18, much obliged, Your Lordship.
More,
marital rape is an offence.
moreover cases, the women can tested by the medical testings, examinations. In this case also check to go through their medical test. for right to bodily self-determination to agree under the Article 21, the right to sexual privacy also given for this marital rape exception. But most of the cases, the affected community precise and especially for women. Most of the cases. So, welfare of the state will avail the most of the credibility to all the peoples. Nothing happened in marital rape. In marriage, the Supreme Court of America will disqualify this petition. In case this is the violation of Lordship, the council seeks permission to move on the prayer. Therefore, in the light of the facts stated, issues raised, arguments advanced, and authorities cited, it is most complete pray and implore before the Honorable Supreme Court of America that it may be graciously pleased to acknowledge and declare the living relationship can be considered as marriage and marital rape can be brought under the purview of living relationship. The implementation of election manifesto by the government is constitutionally valid. The criminalization of marital rape is constitutionally valid. All pass any other order that this Honorable Supreme Court deems fit and proper in the interest of justice, equity, and good conscience. Kindly. Okay.
The council permission to use the dais. Yeah.
Yes, Lordship. Yes, Lordship. The council's permission. Yes, Lordship. Yes, Lordship. The council seeks to repeat the article. Here, this does not come under double jeopardy. The reason is because the the person should be punished for the offense that he have committed, but he is not punished under the very correct provision. 498 though it deals with sexual abuse under marriage. But here, yes, Lordship. But here the contention of the petitioner is, though he's already tried or sentenced, here the contention of the petitioner is, yes, Lordship. So, means challenging that trial only, the petitioner have moved to Supreme Court because she wanted for the man, the Kartik or the accused. Much obliged, Lordship.
Of the marital home and expected a baby soon after the marriage. This made a clash between Kartik and Abhinaya wanted to move back to her family. And Kartik, when she went back to her house, Kartik tried to contact Abhinaya, but Abhinaya did not accept the call or the text made by Kartik. And he wanted to know why she was not interested, why she was not interested to contact Kartik, and she said that she wants some more time to think about the relationship, and she said that she was home alone. On the same day, Kartik was intoxicated and left to Abhinaya's home, there was a fight between them, and Kartik lost his control, and Kartik lost and forcefully engaged in a sexual activity with Abhinaya. Abhinaya first fought, but then she gave the consent to Karthik. Then the next day, FIR has been filed under section 375, 498A and 354A of IPC uh, for Karthik, and the appeal has
Yes, Your Lordship, it can be filed in the both section. If an FIR can be filed, even charges can be filed under both. It depends upon circumstances of the case, Your Lordship, whether what
from the IPC. And they also own the majority. Soon after they formed a government, they
there are
passed.
numerous articles which through which she got affected, and then she's proceeding for the apt punishment for the apt offense that's been committed. Much obliged, Your Worship. This is not asking one more remedy, but this is we don't need the remedy under 498A or 354A. Coming under the purview of rape is enough for the petitioner, because this may be as the act is same as rape. Compelled.
Thought about the relationship, and there was a furious fight, and he hit Abhinaya and bodily injured Abhinaya. So, bodily injured Kriya, pardon me, Lordship, injured Kriya, and Kriya filed an FIR against marital rape on Sunil, where the police came to take the FIR. There was evidence of a marriage between. So here, Priya filed a writ petition under Article 42 stating her complaint must be taken up as rape and it must be granted. The Supreme Court considered all of it for the same question of law and joined the petition and listed the case collectively and hearing on 19th October 2022. But the council seek permission to start with the issues. The first issue will be handled by me, and the second and third issue will be handled by my co. First issue, whether the live-in relationship is considered as marriage, and can marital rape be brought under the purview of live-in relationship? So it is humbly submitted before the Honorable Supreme Court, half of the respondent, that live-in relationship cannot be considered as marriage. The case of Gulsar Kumari versus State of Punjab and Ujawal versus State of Haryana. The court refused to grant protection to the couples who were cohabiting in a live-in relationship, stating that the relationship are morally and socially unacceptable and capable of destroying the social fabric of the Imargan society. And also, therefore, the couples cohabiting together before marriage is often deemed culturally inappropriate and
Includes marital rape under 490. So when this offences get separated, there may be chances of 498 FIR cases to be to come in less proportion. And may I request the bench to repeat the questions that you have raised? Cruelty and rape. Much obliged. Much obliged. Much obliged, Your Lordship. Much obliged, Your Lordship. Cruelty, first of all, as per IPC is concerned, cruelty comes under offences related to marriage, whereas rape comes under offences related to body. So marriage, though marriage is a good institution, sacred institution, when it comes to an individual matter, because individual forms the society, individual forms the family, everything is done by individual. So first, the individual's freedom, individual dignity must be given importance. So cruelty here is a form of domestic violence which is done within the scope of marriage, whereas rape is not such. It is a very broader view as said by the bench, and it can be done by anybody at anywhere and in any manner.
Unacceptable and destroy the societal fabric. So by seeing the judgment, we can conclude that live-in relationship
The
cannot
argument says that it will demolish the culture of the society.
indeed much.
Conditions differ from every 10 years or 15 years. Something will change. Now,
Of marital rape is constitutionally valid. And for this act of kindness, the counsel on the behalf of petitioner shall be duty bound forever, humbly pray. Much obliged, Your Lordship.
The men are being affected in the case of Ansar Muhammad versus Ansar Muhammad versus state of Rajasthan. It has said that if they are in a live-in relationship,
the topic of feminist affected. Generally, I ask you, who are ultimately vulnerable of this concept?
men need
Usually, victimize this concept. Who
men
is
need leadership.
victimized?
Indeed, leadership it's men. Men.
Men.
The council is not.
Who is easily victimized this compound of relationship? On the problem of relationship. This we already know that what is the meaning of relationship. Who is generally victimized on this concept of relationship? Generally asking, who is dancing with you? When are you?
To be some infringement of fundamental rights. There is no infringement of fundamental rights. Firstly, in the issue 1, Sunil and Kriya, the petitioner has an alternate remedy as it has been identified by the Honorable Court. And also they can avail the benefits which has been provided in section 375. She is not interested in the case of marriage. To be specific, Your Ladyship, it has been provided in the fact, Your Ladyship, under page number 5, paragraph number 18. She belonged to a radical school of thought and she believed that the marriage belittle a woman. She's of such an opinion. And how can she claim the Supreme Court for under the writ petition saying that the fundamental rights being violated and she has to be granted marital rape, Your Ladyship? Her alternate remedies definitely will provide in Article 3, Section 375, Your Ladyship, even though she is in a live-in relationship, because it is not illegal. Your Ladyship, alternate remedy is there. Hence, the writ petition does not have a sustainability at all. Pardon me, Your Ladyship? Indeed, Your Ladyship. Only for fundamental right is violated, the person can file a writ petition. Without any violation of fundamental right, there is no ground for the filing of writ petition, Your Ladyship. Definitely, Your Ladyship, that is due to the... Your Ladyship, that is for the convenience of the...
Are you appealing for government in this issue?
No, you lords. No, you ladies.
Are you appealing on this issue?
Sunil.
Sunil. Okay. Sunil. Okay. Okay.
So, no consent. Just like in the case of the first issue in the Kriya or Abhinaya, pardon me, second jury. Yes, indeed, Your Ladyship. Firstly, indeed, Your Ladyship. The question of the matter regarding the marital rape is a question pending in force, Your Ladyship, under Supreme Court, Your Ladyship. In the case of RTI versus Union of India, and also in the case of Farah versus State and another versus State and another WPCR.
Could not be said to fall within the expression relationship in the nature of marriage. Consequently, it was not covered under the ambit of Section 2F of the Act. In the case of Reshma Begum versus the state of Maharashtra, the Bombay High Court underlined that to continue a democratic relationship under Section 2F of the Act, the possibility of the legal marriage is a sine qua non, which is a thing that is absolutely necessary. In the case, the court assert that the impulse provision could not be interpreted excessively to promote adulterous relationship, that the court held that the relationship between the parties was not in the nature of marriage. Therefore, the appellant was not entitled to any relief under the Act.
When having no power, when having no power, the room,
For example, we can't create a new offense, your ladyship. For example, to be stated, recently in Andhra Pradesh, the Supreme Court, your lordship, Honorable Supreme Court. No, we can create a rule. An offense, a punishment cannot be created. It is a procedure which has to be provided by the legislature. We can extend the punishment, but we can't create a new offense. A new offense cannot be created. Your ladyship, according to the division of the legislature has the power to provide all the rules and regulations, your ladyship, and to execute it, judiciary is there, and also to review the application, judiciary is there. But and if the MRA is repealed, even in the case of the split verdict by the High Court of Delhi, also in Karnataka has stated on the same. Pardon me?
also, then how we are going to punish them? They are just involved in this relationship and then simply disconnect their responsibility and disconnect their relationship with her. Then ultimately, it might be only also women community only.
Indeed, your ladyship, but in the fact sheet it hasn't said that Sunil did not want to move out of the relationship. Where Kriya, she filed a false case that she has been sexually
Your
abused.
ladyship, counsel seeks to point out that the petitioner has not read out the entire fact of the case thoroughly, because at the end of the case in the Supreme Court it has held that the living relationship, which is not for the term of other than the purpose of living together and because of cohabiting, if they are not exchanging any emotional relation between, it will not be termed as a living relation, and hence the petition was dismissed and the remedy was not provided in the same case, your ladyship. And also counsel seeks to refer to the points which they have referred, your ladyship. The first point is the couple must hold themselves out to the society as spouse. In the fact, nowhere it has been provided that Sunil and Kriya were specifically going out and they were showing out themselves as even to the neighbors to be married. Though even she belonged, there was no even promise of marriage between the couple, your ladyship. It was merely for sexual requirement. And also in D. Pachayama versus Velusamy versus Pachayama, it has been stated that if it is only for the purpose of sexual intercourse, it will be called as keep, your ladyship. Counsel seeks to point out the term which has been mentioned in the said case itself. But the contrary, indeed, your ladyship, it is cannot be a marriage. Pardon me? Your ladyship, contrarily, it can be called as a common law marriage, your ladyship. Pardon me? Pardon me, your ladyship? Your ladyship, it is not my own word, your ladyship. It has been stated in the Supreme Court, your ladyship. That is the reason I was using the unprofessional term here. It was not my own term, your ladyship. It has been provided under paragraph 105, if I am not wrong, in the Pachayamal case. And moving on further, your ladyship, if it is not called as a living relationship, it can also be called as a common law marriage. Common law marriage is not ceremonial marriage. Even if that is the case, there has to be a consent. There has to be a marriage promise between the couple, your ladyship. Here in the fact, it is also evident that the person is not in the interest of marriage itself. When a person is not in interest of marriage, why are they even trying to come under the marital rape? If they want a judicial separation, they can go for judicial separation and avail section 376B. If not, if they want to be in a living relationship and not be called as a marriage,
Can be considered
pardon me, your ladyship,
The fact states clearly that the neighbors were of a doubt whether they were in a married couple. They were not sure of what the relationship was. And also it shows that in the paragraph 18 itself, it states that, Your Ladyship. It states that the neighbors were not sure what the term of relationship was between them. Because, pardon me? Indeed, pardon me. Even though, Your Ladyship, if that is not the fact, queries, Your Ladyship. Indeed. But Your Ladyship, contrarily, even
Cruel. Leadership?
He applies only to married women, not the women. The whole negligee also not telling to that person. The how she will protect it. You from any harassment from her partner. Okay, proceed.
Marital rape cannot be brought under the purview of live-in relationship. As live-in relationship is not considered as marriage, then the marital rape cannot come under the purview of live-in relationship. In the case of Dilip Pandey versus State of Chhattisgarh, stated that except intestine of finger and radish in her private part, what other unnatural physical relation he made with the complainant, she has not stated, which is a matter of evidence. In the instant case, Priya has said that she has been hit and was bodily injured by Sunil, which has given a clear evidence that there was no assault between Sunil and Priya. So this shows that what women the NGO has stated was actually right, and the removal of MRE may be used as sword by women, whether married or unmarried. And according to the and so here by removing MRE in IPC, it also violates the respondent's fundamental right of the equality and right to life and personal liberty. In the case of Ansa Muhammad, which is state of Rajasthan, they have stated that the women who lived with him lived with the respondent, and when the living relationship turned to be sought, she has filed a rape case against him. But the judgment has said that a relationship with the same person cannot eventually file a rape case if the relationship turns sour, and it was admitted that petitioner had made the relationship with the complainant by promising to marry her, and due to the relationship, a child was born. There was they both mutually got into in the instant case, the petitioner and the respondent, they mutually agreed with the living relationship. So there was a clash between them, and the relationship got to soar. Does not mean that Priya can file a rape case against.
if in case she's not capable of looking after herself, and and the husband is so like not in the interest of marriage, to protect in such a cases, it was considered as a marriage in the good faith, Your Ladyship. To protect the woman, it was such a deliberate action was taken, even for property matter, and even mainly, Your Ladyship, if a child is born out of a wedlock, it is legitimate. So if a child is born out of a wedlock, it is not legitimate. It will be termed as something else. Also, but they will be provided. They will provide the benefits. Yes, they are legitimate, but they will not be termed. They have to again go to the other sequences. They are eligible on the basis of good bona fide interest for the interest of the children. Indeed. Moving on to the second issue, Your Ladyship, implementation of election manifesto by the government is constitutionally valid or not. According to Your Ladyship, the implementation of election manifesto by the government is constitutionally invalid because basically, as stated earlier, there's a split verdict and there is a question of law that is pending in the Supreme Court right now, and this decision will be done upon February 2023. Therefore, assent cannot be taken, Your Ladyship. And also, Council seeks to provide an example which has been passed under the relative states. Even in Andhra Pradesh, recently in 2020, they passed the Disha bill, stating the same for the protection of women, and they try to increase the punishment. But it has not been assented by the governor or to the president because of the
fact that it cannot, the Supreme Court does not have a power to create a new offense, Your Ladyship. And also, even though it is under the concurrent list, if the Supreme Court has the power to legislate, we can make law or bylaw. Only the Supreme Court has power to review the judgments. Indeed, Your Ladyship, it is up to the discretion of the honorable bench. But what council is trying to say is that because of the repeal of the marriage, there will be consequences, Your Ladyship. There will be no formation of a proper society. We are agreeing that the false cases are being lodged. Nearly 14% of false cases are being launched if the MR is repealed, Your Ladyship. And if in case it is 14%, just imagine the families which is being separated because of this, Your Ladyship. Council seeks permission to submit the report. This report is, Your Ladyship, this report is officially from the NCRB on 2020 census, Your Ladyship. It states that nearly 14% of men are falsely accused. This also shows that 14% is not a small ratio, Your Ladyship. Each one of the percentage required represents the family which is being affected by that. Also because of that, a family is being separated here, Your Ladyship. Due to that reasons, and also there is no fundamental right violation here basically. There are alternative provisions to be provided to be protected that protect the women. There are many provisions in IPC, even in CRPC and domestic violence, Your Ladyship. And moreover, a court, even though if a person is affected, we are not relying on it, Your Ladyship. We are showing it as a fact to support the arguments. Wait, yes, indeed, Your Ladyship. That's what our council is trying to say. If the ratio shows that even if it is a rape, still now it is not constitutionally identified in UOI. Marital rape is not identified, Your Ladyship. That is the reason we are showing it on the rape. Indeed. Indeed. Pardon me. Then it is deliberate, Your Ladyship, that marital rape cases are not being filed and people are having consent and it is not come under the marital rape. If the person is being separated, if the person is in separate, for example, if the person is having some conjugal misunderstanding and if she is living with the parents, just as in the case of Abhinaya, it can be filed in the session.
Right? Then only the government, the party has passed the resolution regarding
Much obliged, Your Ladyship. In the case of the High Court held that the sexual intercourse between the husband and wife will not count as a sin. So here the discrimination, which means the discrimination which actually doesn't take place in the relationship between the husband and wife. So here the Article 15 of the discrimination doesn't actually violate it. So we are saying that class 3 doesn't have any effect to make any provision to the women and the children, Your Ladyship. There is no any violation of the discrimination and there is no any discrimination to the woman here, Your Ladyship.
There is no discrimination.
There is no discrimination, Your Ladyship.
By way of marital rape.
No, Your Ladyship.
This is my opinion. You are discriminating the married women who are completed 4 years.
No, Your Ladyship. They were actually voluntarily fell in love and also enter into a relationship and get married according to the Hindu law. So here, as per the law, provides that the equality should be given to the women men also. So here it is clear that the equality should be given to the men also. So here the criminalization of marital rape is actually unconstitutional, Your Ladyship. Much obliged, Your Ladyship.
And also, on behalf of Karthik, contending that it would lead to misuse of 498A of the IPC, the case in regard of state business RJ stated that in that case not be separated, there will be no such marital rape. There will be a perfect consent. Without a consent, a man cannot approach a wife. That is the main contention why they have been divided into three parts of relation. Much of leisure leadership. Also in leadership, the reason why court cannot go into the sanctuary of spaces, it is a privacy within a privacy. One cannot prove if the marital rape has been done by a husband or not, if the marital rape exemption has been provided. With that, your leadership and also according to Article 200 your leadership, even if according to Article 200, as stated earlier, if the assent is also provided, assent cannot be provided by the governor or the president of the Supreme Court of India, as it is a pending question of law in the High Supreme Court leadership. With that being said, Council seeks to conclude the part that the first issue regarding the living relationship shall not be considered as marriage in all the cases, and hence it shall not be coming under the purview of marital rape. And the second issue would be the election manifesto implemented by the union of by the state government shall be constitutionally invalid. Council seeks permission to move on to the third argument and approve. Much obliged.
Your Lordship, Council is dealing with the issue in the present case, Your Lordship. Whether the criminalization of marital rape is constitutionally valid. Your Lordship, no, it's humbly submitted before the Honorable of Supreme Court of India that the criminalization of marital rape is constitutionally invalid, Your Lordship. On the following ground, firstly, there is no support available either statutorily or precedent that every act of non-sexual act by man with his woman is rape. So that by man whose wife having a sexual activity or a sexual intercourse with this wife, it does not consider as a rape, Your Lordship, and does not require consent or lack of consent, and it does not require as a force or pressure or injury. There is a case law, Your Lordship. Guru Devata Vikas Mariadati Owes vice the state of Maharashtra on ORS 22nd March of 2001, Your Lordship. It says under the judgment, every word used the statute to be treated as deliberately as well as constitutionally used and entered by the legislature. Whether the legislation has not used expression of contextual activities, force, or any expression indicating the absence of willingness of consent. Your Lordship, the imperative exception of section 375 of provisions condition says that the sexual activities as sexual intercourse by a woman with his wife are not a rape. It does not require consent or lack of consent, Your Lordship. Council seeks permission to record a compendium of respondent page number 5 of second paragraph. And Your Lordship, the intent of the legislature of intersexual intercourse and sexual acts without referring on to presence. Your Lordship, marriage is neither a playground or a glad-tearing era. The sexual aspect of one of the many facts of the relationship between husband and wife, which the bedrock of the marriage was, catch consideration and understanding one another, like the dislike of home as consideration and sharing the fundamental rights and civil duty. This case law, Mr. X versus Hospital is at 1998 S 1998 8 SCP 296, Your Lordship. And as we all know, marriage is a second union and in a social institution. Legally, a permission of two healthy bodies combined together opposite sex of generations. Second, sex. Yes, Your Lordship. They have a separate power as well as rights and duties behalf of their will, right? Behalf of Your Lordship.
Yes, your lordship. Even the concern as well as their own body have their own rights. If she want to believe or not, it is her own concern, your lordship. Yes, your lordship. Well, if you want to have a as per the existing either right for all people. Already
Lastly, in case of Subramania Balaji versus Government of Tamil Nadu, the Supreme Court said that the Supreme Court have granted that direct the election commission because of there is no any provisions regarding to the election manifesto. So the Supreme Court directly.
taking your lordship. Then one thing.
So the election manifesto, as per the order of the Supreme Court, made the guidelines regarding to the election manifestos. It was stated in the 79th point of the judgment, Your Ladyship. In that election manifesto guidelines, in MCC is also called as MCC, Model Code of Conduct. And the part 7 of the guidelines says that the party in power should not have, actually have the restricted power, power or leadership. Here in the party in power says that the authority have no, the authorities and the ministers have no right to make the promises after the announcement of the date of the election. So here in the mod provision says that state of province was scheduled its election in a year. So here it is clear that the state of province have announced the date of the election. So as per this part 7 of the party power, it is violating, and also article 13 slash 3
Violating.
uh, it's in legislation. The guidelines have been violating, Your Ladyship. Election manifesto made the guidelines, Your Ladyship, and the guidelines
Not making
it is violating the state is violating, state government is violating that.
How violating
Much obliged, Your Ladyship. In the party in power, there has been a there has been a
they are not in party power. That's the fact. They are.
but it says according to the
That's it. They are the nationalists. How it is violating the same as you said.
by
provision does not violate the Article 21 of the Constitution. Your Lordship, she is protected under section of 376B of if she is separated, Your Lordship. Please, section 376B. She is not separated. She can be not out. Pardon me, Your Lordship. She is not separated. No, Your Lordship.
Not in practice. Practice.
in what proposition?
There is no statistic for name, but she's protected under priority. Then thirdly, the court cannot create new offences also. The lordship, the petitioner has relied upon the independent case of proving that criminalizing marital rape does not create new offences. Depend of the offense has been created, so that the Supreme Court has been created what? Like, Your Lordship, there is a sexual harassment. After the after 20 years, if the father is was saying that people have no power to leave anymore. According to the offense has been created, the Supreme Court has certain powers to create new offenses. There are certain foreign jurisdiction, Your Lordship. This issue is whether to strike down the impact exception as unconstitutional. Council seeks to point out the case of Puttaswamy, where Supreme Court observed that there is a nine judge bench in this case, announcedly reformed the right to privacy as a fundamental right under Constitution of India. According to the Constitution held that the right to privacy was integral of the freedom as well as guaranteed approach to fundamental rights, and it was instead aspect of dignity of liberty as well as autonomous. Consequently, Congress humbly produced that on the above grounds of criminalization of marital rape has no constitutionally validity, and hence challenge cannot be sustained. Government seek permission to move on to the claim. Therefore, in light of the fact stated, issues rise, arguments advance, and authorities cited. It is most humbly prayed and implored before the Honorable Supreme Court of India that it may be gradually pleased to dismiss the writ petition, declare that the election manifesto of democratic movement of province is constitutionally invalid. Declare that non-consensual intercourse in a living relationship is not under the purview of the marital law, and are also pass any other order that the Honorable Court deems fit and proper in the interest of justice, equality, and good conscience.
My friendly counsel said that there is no infringement of fundamental rights. It is very apparent, reading the facts as well as the circumstances of the cases, that there is a violation of fundamental rights. as even pointed out by the bench that the women are classified into three sectors. That is itself a fundamental right violation among the women, and also when compared to men, there is an obvious infringement of fundamental rights. And when there is a fundamental rights, no need to seek for alternative remedy. We have a direct remedy of writ. So alternative remedy that doesn't come into this matter at all. And regarding the living marriage, Malpenti Council said that, Auckland Council said that the neighbors were not sure of, or they were not, they just believed that they were married, but they were not sure. They had certain queries. Queries, after the fact, is only regarding the making of the tali, which is a kind of token for a marriage. Keeping that apart, there is a convict. They have been living for 5 years, and in 5 years, that no.
Otherwise, it does not violate Article 15 by criminalizing the marital rape by stating that Article 15 of positive discrimination, there are a lot of legislation that comes within that aspect. For example, POSCO, which also protects the married women who are within the age of 15 and 18 too. And it does not violate the Article 21, which was held in recent judgment. Ex versus Principal Secretary, Health and Family Welfare Department, Government of NCT Delhi in 2022, the Supreme Court bench led by Justice Chandrachud state that for the meaning held that the meaning of rape must be include the marital rape in the purpose of medical termination of pregnancy act 2. So they didn't consider that the marital rape, considering marital rape violate the Article 21 of the Mill. That's all.
The Constitutional Commission to Salvador. Much obliged to your ladyship and lordship. Here, the learned counsel for the petitioner, speaker one, says that it was not. She itself says that it is not violating the Article 14, 15, and 21. And also, they stated in the memorial in a page number 9, it was violating the Article 14, 15, and 21. So it is contrary to their argument. So and also, ladyship, it is she says that unreasonable manner, and here this is not actually in an unreasonable manner. So Article 21 also includes the right to privacy for the men also. So here the equal protection to be given to the men and the privacy to be given to the men, and also the criminalization of marital rape is not under the control of the state itself; it is also under the control of the central. So here it is made towards whole the country. So here the family inclusion given the more importance than the personal single person their ladyship. So much obliged, your ladyship. Thank you. Uh, Section the rational behind this object is originally investigated from the Macaulay, which has been provided for the protection of conjugal rights of the husband, your ladyship, and it has been evolved over a period of time. And even today, the legislature hesitates from it. Admittedly, to preserve the marital, it is to preserve the marital institution alone, and there is no other reason backed by this your ladyship. And moreover, when one examines these aspects against the backdrop of sexual assault by a stranger and consensual sex between a husband and wife, the distinction between the two becomes very apparent in this violation. And women who railed on by a stranger suffers a sexual assault, even if it was a far short of the actual rape violation. With this counsel states to answer much about it.